Welcome, everyone. I am thrilled to be here today with Clay Brewer, who is a partner at Thompson Burton. And you're an MLM attorney, correct? Is that what you
Right.
call
Yes.
yourself?
Yes. Sure.
Clay, I get all kinds of questions and people making statements to me about things. And I thought, oh, geez, I've heard so many things in the last several months that it was time to do an update with a professional, a legal professional, an attorney who actually knows what the rules and regulations and the laws are. So I've got some things here, some questions people have asked me and some statements people have made. The first one is what somebody told me. The rules have changed. And now, because of the FTC, every network marketing company must have 3 customers per affiliate. Is that true or not?
It's not true. The rules haven't really changed since 1975 in the Costco case. We've had certain kind of iterations since then, but the FTC tries to move the goalposts as we've seen in guidance or advisory opinions, but the traditional kind of what's a pyramid and those aspects have not changed. So there's no 3-to-1 ratio or anything. It'd be nice if we had some clear numbers, but unfortunately the FTC and other regulatory agencies like to live in ambiguity. So that's kind of where we find ourselves still.
So there's not even a regulation that says for every one affiliate, you have to have 1 customer.
Technically, no, there's nothing like that. Of course, the more customers you have, the better. But really where we're at is kind of a spectrum of what's legal and what's not. So how can you present your case in the event the FTC or others were to come knocking? And kind of what data do you have?
So there's not even a threshold that says more than 50% of your revenues have to come from customers, because that's
You
another
know,
one.
yeah, that was always kind of an idea. Of course, if you have more customers than distributors, that's always a good thing to kind of demonstrate that customers are prevailing within your system. But even there was a recent FTC advisory opinion letter. Again, advisory opinion letters aren't law, but it kind of gives you a way to read the tea leaves of what the commission might be looking at, right, for certain things. And they wrote
Yes.
up to the DSA in March and said that it's not a percentage-based test. It's how it operates. Can't remember the words they use, but like um, how it operates in practice or something like that. So you could theoretically, under that framework, you could have 90% customers and they could still find issue with what you're doing. Again, I think that's a very weak argument, both just naturally then also under the law as it is right now. But that's kind of the world that we're in.
Okay. Now, this is something that I've always thought was true, and I don't know if it is true or not, but what I've heard many times was that affiliate marketing companies can pay up to 2 levels deep. Once you get into a compensation plan that's 3 levels deep and deeper, it changes. And from a legal point of view, it has to be categorized as a network or affiliate or multi-level marketing company. Is that true?
Not necessarily. So it's a really interesting question. I'm not sure what really originated the distinctions between like direct sales, network marketing, affiliate marketing, multi-level marketing. We have all these different kind of terminologies want to use. I think some people tried to get away from the MLM designation just because that's kind of faux pas at times. You see MLM,
No.
you want to run the other way, even though it's a legitimate business model, always has been, always will be, in my opinion. But affiliate marketing, this is just my interpretation, not really a legal one, but affiliate is more so where you have 1 level, so you earn commissions off of whatever sales you generate. When it comes to network marketing and direct sales, I guess that can kind of encapsulate affiliate and multi-level and all of that, but it's kind of used synonymously as well. But I think 2 levels and more is multi-level marketing, right? Multi-levels. So that's more than 1. That's how I've always defined it. But it doesn't really have a legal definition. Like in certain cases, they don't outline this is what it is, this is what it isn't. It's just more so. I've had a lot of clients come to me saying, oh, we're only 2 levels, so we're going to call ourselves affiliates. I've even had clients that are actually in MLM who name their distributors affiliates. So it can get really kind of convoluted quite quickly. But there's no like black letter legal definition for the distinction.
This is great. It must make your job so easy because there's nothing that's
Right.
black and white. It's all gray.
Yeah, I think it's good job security because the ambiguity is kind of what we live in, but it's unfortunate for a lot of clients because it's extremely easy to get in the weeds really quickly and just confuse yourself. And then even as we've seen lately, convince yourself that the industry is not sustainable, which is
Yeah.
extremely unfortunate because there is a way to do it right. And just because a regulator has an opinion on something, doesn't mean that it's right. And so thankfully we've had companies, for example, like Neora, who are willing to put their money where their mouth is and keep fighting and hopefully prove that the industry has a lot to build on and a lot to offer people.
Yeah, that's great. Someone recently said to me, Gloria, matrix comp plans are illegal.
This is the one time where I might slightly, again, take it with a grain of salt, but agree with the FTC in a sense that it depends on how you operate in practice. A matrix plan, of course, when you fill those different levels, it very strongly incentivizes recruitment, right? And so if
Yes.
recruitment overbears the general focus of the company and the customers that you draw in, or the products, genuine products, not just a random pencil that you sell for $1 million or something, right?
Yep.
Then that's really what the ultimate factor would be. So I guess to answer your question overall, matrix plans in themselves are not illegal. So if you see a plan that has a matrix, it's not illegal just by being there in itself.
Okay, good. Here's another one for you. That these membership comp plans, like Live Good, I'm just going to say Live Good because so
Okay.
many people, we all know Live Good, just has just exploded over 1 million distributors or members in a little less than a year, and it's continuing to grow. And so many other companies started comping that comp plan. It's a really low entry point of $40 and $9.95 a month. I've had a bunch of people say, that's illegal.
Yeah, so I won't speak on Live Good directly, just not familiar with their work entirely. Generally speaking, when it comes to memberships, the same rules apply, whether it's a service-based product or a physical cosmetic product or what have you. Right? So the Costco test is what determines what a pyramid is. And the second element of that is rewards unrelated to product sales. And so what is a genuine product is really what we need to fall back on. And then why are people buying it? And so if that's where kind of the percentage-based tests come into play, are just individuals that are members buying your service? Are they just buying it for the opportunity to recruit others? Then that might be an issue. But if there's a genuine use case of whatever that membership might be or whatever that product might be, then it's fine. It all goes back to what is I hate using this term because it's very subjective, but like what are the motivations behind the buying? And once you see people's buying practices, then you can kind of tell why they're buying. Like if they're buying a certain amount at the end of the month and that's it, and no more the rest of the month, then it might be illustrative of bonus buying or trying to qualify or something like that. But if they're buying it in normal just use cases or anything like that, then it's fine. So again, a membership in itself wouldn't be illegal. It's really what does that
Okay.
membership do, who's buying it, and why.
Okay. So this kind of follows up with what you just said, because somebody else has also recently said to me, it's illegal to pay commissions just from membership fees. Is that true?
It's not. So it kind of goes back to what I just said. So it all comes down to if it's recruitment based, of course, you can't have commissions tied solely to recruitment. So for example, if I have to pay, I don't know, $20 to join a program for the right to then market to other people, and then that kind of keeps the tree going, right? A legit, like an actual pyramid, then that's an issue. But again, by being a membership, it really depends on what that membership is. So for example, Costco, right? You buy a membership and you have the right to go to that store and buy whatever you want within that. I think taking that analogy a bit further, let's say that I had a Costco membership, right? And people were buying all these memberships, but no one was ever actually going to the store to use it, then that might be a bit of an issue, right? That people aren't actually using what the membership was meant to promote. But if the service is to access this kind of like its basket of other goods, or if it's a service in general, like a travel program or something, then that's a legitimate offering.
Okay, good. Here's another one that someone has recently said to me. There's been a huge change in the laws, and network marketing companies can no longer require that you only are a member of one company.
I'm trying to think on that. So imagine it's the FTC's non-compete rule is probably what they're alluding
Yes.
to.
Yeah.
So district court in the state of Texas actually set aside that rule, which means that it did not go into effect on September 4th as it was planned to do. And so that's still up in litigation. I imagine the FTC is going to appeal that. So that ban on non-competes that the FTC was trying to effectuate is not enforceable. And saying that, a lot of people were misconstruing that rule as well, as it still let individuals or individual companies have non-competes on concurrent employment or concurrent relationships. So independent contractors, for example. So if I work for company A, I can be restricted from working for company B during my time with company A. The restrictions on that rule were actually once I'm terminated or otherwise from company A, I could go to company B without any restrictions. So that's kind of what that rule said. But broadly speaking, non-competes are still active and fine. It obviously comes down to the scope and the reasonability, and there has to be a proper business reason for that. And so when you're an independent contractor with a company, it's hard to prevent someone from doing something, because that then gets into a different conversation of whether you might be an employee or not, because that company is exercising excessive control over you. But that's really a case by case basis. And so it broadly speaking, they can prevent you from working for another company, but non-competes have kind of been going out of favor because of that control factor and just bad business and otherwise. The real teeth when it comes to network marketing would be like a non-solicitation. And so a company has the right. And so like, for example, if I'm representing a company, we have the absolute right to draft in the policies that you can't just download your entire back office or download from your back office, your downline, quit, and then just like blitz all of them and bring them over. That's just, the company absolutely has a right to prevent that. And we've seen it happen. So I heard a story recently where an individual would be at the new company's headquarters and would be downloading the downlines, and you could see the IP address of where they're downloading it from. And so that's pretty easy to prove. That's an issue, right? That's just bad business, and the company has the right to enforce that. So I know I talked a lot there, but essentially, yes, they can prevent you from doing things still.
Yeah. So let's say a health and wellness company at this point in time, because the law, because of the judge in Texas, a health and wellness company does in fact have the right to restrict you from being a member, an affiliate in a competitive health and wellness company. As an example.
Yes. And then regardless of that rule, before and after its implementation, they could restrict you from, like I said, concurrent. So at the same time, whether it's smart business wise or whether the individual states have further restrictions would be up to a case by case scenario. But yeah, broadly speaking, that's still fine.
Okay. Here's another one that someone recently.
Yeah, these are great. I love this.
But you know what? These are real life scenarios, right?
Sure, I hear them every day, so it's definitely great. And you hear it slightly different, and it might modify your answer or kind of make an it depends answer. So it's fun to me.
Yeah. So someone recently told me that in this particular case, the person got their distributorship taken away by the company. The company thought that they were doing something unethical.
Terminate or something, sure.
Whatever. I don't know. It was something against the terms and conditions, right? So the person got their distributorship taken away. And but the person still has a downline, right? And they had commissions owing. So let's say you get paid on the 1st and the 15th of a month, and you get your distributorship taken away on the 14th of the month.
Sure.
Does the company, in fact, owe you the commissions that you've actually earned up to the 14th of the month on the 15th? Or because they terminated your distributorship before the 15th, they don't owe you those commissions?
Yeah, I'm going to give the favorite lawyer answer of it depends in that scenario, right? So there's kind of two sides of that same coin. So termination could have been for a variety of reasons. And if those sales were made legitimately and everything, then I think it's good business to pay out those commissions if they've been earned. But if that termination originated from for whatever reason that then might let's say compensation plan manipulation, right? Or or bonus buying or one of those things, if
Whatever.
those commissions were earned through ill-gotten gains, then I think the company has the absolute right to not pay out those funds. So it'd really be factual based on the scenario and also the policy. So this is what individual distributors need to really understand. I want to hammer home for both the company and distributors. This is a binding contract. It's not just terms and conditions that may or may not apply, like for a refund for Nike shoes or something, right? It's binding, it's contractual, and so you need to read those with respect and under the assumption that they will be enforced against you. And so the company could have a variety of reasons for not paying out, and that would be within their rights. Obviously, subject to certain legal objections, but under that contract, they have the right to operate as they seem fit. So it's extremely important, and I think a lot of individuals forget, and especially with distributors, they're independent business owners as well. And so I think it's important to act as such.
Yeah. And, look, I would say that 99% of distributors never, ever, ever read the terms and conditions.
I would unfortunately agree with you on that. Yeah. And then sometimes companies might copy and paste from a different company. And it's just, yeah, I think both sides need to take the construction of those much more seriously. And then when you engage the field, you get feedback. And I think it needs to be like I always say, that symbiotic relationship between the field and corporate. And I think that makes situations like this hopefully not arise because everyone's on the same page and know what the expectations are and obligations are. But
so along those lines of, in this case, the person was terminated, but and then wasn't paid the commissions. But let's say something happens and you had fraud on your credit card, so your credit card got canceled, but you had it in there for your auto ship. I mean, I know personally, I've got so many things on auto pay for credit cards.
right,
When I have fraud on a
Netflix,
credit
Disney,
card, it's
everything,
like,
right?
I have no idea
Right.
what's on that as a monthly basis. So then your auto ship doesn't get charged, but you had a whole bunch of commissions due to you, but you weren't active because your auto ship didn't get charged, right? In that case, does the company owe you the commission?
Again, I would go back to the terms and conditions, but the way you've outlined it, I would say that they do, because if those sales were generated and then you're not usually, so if I were to draft company's policies or something, you want to have a bit of a grace period for explanations. I mean, I think it's just bad business to randomly just cut people off with no explanation, kind of thing like that, right? Of course, there are certain scenarios where certain things like that might happen, where things need to be expedited or something. But in that scenario, yeah, I mean, you've earned them. It seems like it'd be an easy thing to remedy, talking to the compliance team or just explain the scenario. I
Right.
doubt there'd be much issues with a stolen card kind of thing.
Right. And the bottom line is, it is incumbent on the distributor to read the terms and conditions of the
Right.
company that they're
Right.
with, which they don't do. And it's
Right.
like,
Right, because usually in that scenario there'd be somewhat of a, what's the word I'm looking for? Like a support process, right? Of
right.
you have
Yeah.
30 days to review your commissions or et cetera, or something to that effect. And so you want to take ownership if again, it's your business. I think that it's extremely important to emphasize in this industry that it's not just the company operating a business, that it's the individual um, operating a business as well.
Clay, you're in the trenches all the time with legal issues with network marketing companies. Do you have any trends that are happening that you're seeing today that we should be aware of, that we should be thinking about?
Yeah, I mentioned like the FTC guidance and advisory opinions and things like that. I would recommend, if you're a distributor or just curious onlooker or a company executive in particular, to read those, because it still gives you insight into how the regulators are looking at certain things, right? Because like I said, it's very easy to get in the weeds and kind of confuse yourself from many contradictions, perhaps in advisory letters, or you see things in case law. So, for example, I think a great example is the industry, rightfully so, was extremely excited for the Neora decision, right? That the
Right.
Neora was able to defeat the FTC, but that was decided in September of 2023. But then in March of 2024, the FTC issued those advisory opinions, one to the DSA, one to the DSSRC. And pretty much completely ignored that entire ruling. And so that tells us something, right? That we need to not just rest on our laurels and rest on one district court opinion in Texas, because if you're sued in New Jersey or somewhere, that case means nothing other than it's just what's the word? Persuasive. It's not binding on that court whatsoever. So it's extremely important to understand that. And so I
Right.
think that it's best to understand the overall framework of what's happening because it's a very political industry. So regulators are appointed by the president or they have their own political leanings and things like that as well. So it's extremely important to understand that there are people out there that genuinely hate the industry, whether it's network marketing or crypto or whatever industry it is. It's also easy to look at other industries and how they're being attacked or otherwise to read the tea leaves of what's happening in your own and maybe adopt or not adopt certain policies that those companies have made in those industries.
So for those people who aren't aware of the Neora decision, can you give a very brief overview of what happened with Neora?
Sure. So there's a lot that went on, but essentially the FTC sued Neora, stating that they were a pyramid scheme among a variety of different product claims and things like that. The FTC had their arguments. Neora rebutted with their data and arguments, and the FTC essentially couldn't convince the court with their responses. And so, on all counts, when it comes to the pyramiding, et cetera, Neora prevailed in that scenario. And so it goes back to the very first question that you asked about the ratio between customers and distributors or the 50-50 percentages or anything. The FTC, and an economist that they like to use quite frequently, Stacey Bosley, tried to argue that the majority of individuals within Neora, so brand partners is what they called them, lost money. So sure, that sounds bad on its face, right? That might be a pyramid because people aren't making money, even though if you're operating a business, you should, right?
Right.
And then they tried to argue that individuals, if you were a brand partner who simply bought product, that you weren't a customer. And Neora prevailed on the fact that individuals enrolled as brand partners to an extent because they enjoyed the products and for the discounts of the products,
Mm-hmm.
as opposed to the opportunity and wanting to build a downline and wanting to grow commissions, right? And so the court had a nice little line that said, well, okay, the majority of brand partners lose money. Okay, check. But when I go to the grocery store, I lose money, but I come back with some type of value, right? So that was a really interesting idea of a pyramid can't be broken down as simply as people lose money. And
Right.
we've seen, just to kind of keep this forward and tie everything together, the March advisory opinion letter sent to the DSA expressed that a lot of people lose money in this industry, but that defeats the whole point of what the New York case was trying to illustrate. And so it's going to be really interesting to see if the FTC, or should I say when, not if,
Yeah.
how their next arguments go, because I guarantee they'll try similar arguments in the future. But I think right now, relying on that case, simply because you're a distributor does not mean that you're building a downline or building a team. That's why it's critically important to be transparent. And if you're a company and you have an argument or a presentation that you're making to the public or internally or whatever, you need to have substantial data to back that up. Because even if it's true, if you can't present it, then it's no good to you. And so that's why I know I'm going on a bit of a tangent here, but that's why in the Neora case, like when you're enrolling as a brand partner, for example, it was nice that they had surveys to ask kind of why they were doing that, right? So if
Mm-hmm.
it's for the discounters or for the opportunity, if someone
Right.
puts in a survey, I want a yacht like person X, and that might be an issue if you're getting a lot of those, right? But if it's a
Right.
one-off, primarily because they love your makeup, then that's a phenomenal data point that you're doing things right. So,
Right. Well, and it also goes to income claims, right? We just have to be so careful about income claims when
mm,
we're out there doing YouTube videos or TikTok videos or posting something on Facebook or
mm.
Instagram, just stay away from income claims, right?
Right.
That's another
Yeah,
thing.
I mean, the gold standard, unfortunately, in the FTC's eyes is no income claims, right? And so that kind of takes away the need for an income disclosure statement and all of the craziness there. But I don't think I'm going out on a limb here speaking. I think the income claim kind of guidance the FTC has given is just ridiculous because all claims are inherently atypical. You will
Yeah,
never have a typical claim. It's impossible because even if you and I do the exact same thing, we might be $1 off, and so that's not typical because it's not the same.
right,
So if I said $100 and you made 101, I mean, I'm splitting hairs here, but I'm doing that because that's what the FTC does as well. They split hairs.
right.
They recently, I believe, let's see, this is so a few weeks ago, I believe, the staff of the FTC released a staff report entitled, what is it? The FTC staff report on multi-level marketing income disclosure statements. And they kind of did like a 20-page assessment and analyzed 70 companies' income disclosure statements. And just the way they one about it was saying that all of these are misleading and you needed to have proper expenses. And they would then say, there's a really funny quote in there, like throughout the process, they would say, and using algebra, we found X. Well, it's just, I don't know, it's ridiculous, honestly, because expenses are going to be different.
I mean, I'm a full-time network marketer and I have very high expenses, but I do it full-time for a living
Right.
and I make a full-time living doing it. So my expenses running my network marketing business are over $10,000 a month.
That's not
That's
typical, but yeah.
Yeah, that's not typical. And
Mhm.
that's my choice, right?
Right.
It's just holding a
But
gun to my head saying you have to
yeah.
spend $1,000 a
And so I think on that note, the one way to kind of acquiesce to some extent is let's say you have an enrollment fee, whether it's annually, monthly, or whatever. That can be a typical expense that everyone's paying for as long as they're in the company. That's
Yeah,
something that's easily disclosable, should be disclosed. There's no reason to hide it. And transparency is always key. So I like to always say, if you have to tilt your head and wink, like squint a little bit to convince yourself the numbers are saying what you're saying, then you might need to modify it. But just don't
right.
get cute with the active versus inactive or who bought what when. You kind of get a clear picture of the average individual. But obviously, you don't want to say, unless it's true, of course. I mean, the truth is always a great thing. So if everyone's making $1 million, then and it's true, then that's great. But
Sign
don't
me
let
up for that company, okay,
yeah,
Clay?
right.
Yeah,
Exactly. It's always better to underpromise and overdeliver than overpromise and underdeliver because the ones that receive the underdelivery always think they're going to be the top dogs, and unfortunately, someone has to fall to the bottom to create that average, right? And so,
absolutely.
if you are extremely conservative in your approach, then um, whatever they receive from that ideally would be much better than kind of falling short each
Yeah,
time.
I bet you want to work for the law firm where every lawyer, every clerk, every paralegal, whatever, is making over $1 million a year too, right?
Exactly.
I mean, I hope you've listened to our conversation and you understand more that these things are not black and white. So when people make statements to you about binaries are illegal, matrices are illegal, that you have to have, X% of your sales come from customers. Well, those are not laws, right, Clay?
That's correct. And I think that if you operate under the idea that there's going to be individuals that just frankly don't like the industry, it's extremely important to kind of have facts and data and everything to back up whatever you're trying to say, as opposed to fighting on an emotional level, because a lot of the back and forth is on social media and things like that. But I mean, network marketing is a phenomenal way. There's lots of wealth that's been created and lots of value, whether it's products or otherwise. So I think driving forward with that positive message, but not the overly like Pollyannish
Right.
message, right? But just being realistic of what the law is, um, will help, as opposed to you're a pyramid or you're not a pyramid. That it's very subjective, as we can see in the FTC's eyes, of course. And so you need to have a way to maybe present that a bit better of this product does X, or we have 85% customers who order monthly. And those are really tangible things that people can process, as opposed to just seeing the MLM acronym or something and kind of getting spooked
Right.
at the outset.
Great. Clay, thank you so much for your time today. This is really, really helpful and really interesting too. So really appreciate it. Thank you so much.
Thank you so much for having me. I have a blast as always.